Welcome back, guys. We've actually been doing presentations all over the province, which has been super exciting. I know the last video we did was how interest works and what the consequences are to not paying your debt. And as promised, in this video blog, we're going to be doing how to seek help from your bad debts by ways of a debt restructuring court order, such as administration or debt review, depending on your certain circumstances. So a debt restructuring court order is obtained through the magistrate's court to protect the debtor's assets and income. This can be done when a debtor makes an application in the prescribed format through an accredited debt review counsellor or administrator that creates a formal and legally binding agreement between the debtor and their creditors to pay their debt back over time. So the application will include, but it's not limited to, the debtor's personal details, their employment details, the proposed repayment plan that is affordable to the debtor as well as accepted by the creditors, and the consent to administration or debt review. In the next step, a copy of your application with all the supporting documentation will be delivered to each creditor within the legally required notice period to allow them to object to the application accordingly. A court date will be set for this application to be heard, where the debtor and their lawyer, which is arranged by the administrator or debt counsellor, will appear in the magistrate's court on the date that is set by the clerk of the court. The application will be heard by a magistrate, where the creditors may also attend should they wish to object to the debt listed in the application, provided they furnish proof of the same. The magistrate will then grant the application, adjourn or postpone the application, or decline the application. If the application is granted, the administrator or debt counsellor must then inform each and every creditor of the granted court order. Now, in the case of administration, the debtor's employer will also need to be informed. This is because the administration is paid via means of a garnishee order, unlike debt review that's paid by ways of direct debit from the debtor's bank account. It's important to note that under administration, all other garnishee orders relating to that debt that's been included in the administration will be removed, and only your monthly installment for the administration will remain. The administrator or debt counsellor is required to maintain that file, which includes having a comprehensive list of all the creditors that you owe, showing details such as each creditor's name, the installment amounts, postal details, references, and balances owing. The debtor is now protected by a debt restructuring court order that allows the debtor to pay one affordable installment a month for all of their debt. Statements can be requested by the debtors at any point to track their progress on paying off their debts. Distribution statements will also be provided to each of the debtor's creditors, as well as a copy given and stamped by the court. This court order also means all the debtor's creditors must communicate through the administrator or debt counsellor and can no longer harass the debtor telephonically or via mail or in person. And that is how you seek help from a debt restructuring court order. In our next video, I'm going to show you how you can go onto DNR's website and do an online application form from the comfort of your own home. And as always, if this video is at all helpful, please follow us for more legal and debt management advice.